The content of this video, as well as the thoughts, views, and opinions expressed herein, belong to the presenter and do not necessarily reflect the views of Brigham Young University or the Church of Jesus Christ of Latter-day Saints.
Hi, my name is Rob Bolick. I'm an attorney still practicing. A little bit about my background. I've been in estate planning my entire career. We did undergrad at BYU, did law school at BYU, graduated in 1981, practiced up in Salt Lake for about 4 years, been down in Las Vegas since then, and a few years ago we moved up to Midway, where I live, and still commute to Las Vegas, practice here in Utah a little bit. My entire career has been in estate planning and asset protection. This is a series of 4 different presentations. We'll go over some of that. I guess probably my only claim to fame is I had a trust class from President Oaks. He is in Dallin Oaks. He was the president of BYU at the time. He taught 1 class each semester at BYU, at the law school, so I attended that. Again, my claim to fame is my highest grade in law school was in trusts and estates from President Oaks, so I knew this is what I had to do. Okay, so this is one of 4 different presentations. So today what we're going to talk about is the basics, estate planning 101, how today is different from the past. We're going to talk about wills versus trusts. We'll talk about what is probate and how to avoid it. We're going to talk about the hidden dangers of joint tenancy. There's a lot of problems with that people they have no idea. So hopefully by the end of this presentation, you'll be a little better informed about how to hold your title to the assets, what to do, what not to do. We're also going to talk about trusts, wills versus trusts, kind of the basics of trusts. Our next presentation in the series is going to be more of advanced estate planning. So today we're going to go over some of the basics, and then next time we'll go into a little more of the finer points. So that one talking about how you can protect the kids and those you care about from the rest of the world. So it is possible to not just you pass away and you give the kids, here's $1,000 in the envelopes, whatever, have a nice life. You can set up your estate in such a way so that they can be protected against all the bad things that may happen to them in the scary world that's out there. Let's go ahead and jump into today. So why bother with estate planning? Might as well go to Paul, Timothy 5:8. But if any provide not for his own, and specifically for those of his own house, he hath denied the faith and is worse than an infidel. And we don't want to be infidels here. BYU do not believe in infidelity. So what we're talking about is planning, preparing. In the world, they speak of property ownership. As members of the church, we think of it not so much as ownership as stewardship. The earth is the Lord's and the fullness thereof, so he owns it. This is his planet, his stuff. We just are stewards, and the question is, how are we going to take care of our duties, our responsibility, our stewardship? So moving on. Here we have John. Costco now has caskets that you can buy online. Now that actually is true, okay? They're not by the rotisserie chicken or back by the water. It's all online. So if you're planning ahead, you can get the bargain basement thing. My dad, he always told us, I just want a pine box, nothing fancy. Of course, when he passed away, we didn't pay attention to any of that. And, the funeral is not for whoever the deceased is, for the family. So, Mary. Well, now that's the last thing I ever need. Good point. However you view it, you want to take care of your stewardship. So one of the things is that doing estate planning doesn't really benefit you. The estate planning is simply how do we pass from you to your beneficiaries, the kids, the grandkids, charity, wherever you want it to go. So the benefits are not for you. You're doing something selfless for them. It's kind of like life insurance. Life insurance is a bet you want to lose. So with life insurance, you're betting the company that you're going to die. They're betting that you're not. And so most people that have it, you have it there for your protection, but that's a bet you want to lose. Anyway, it does nothing for you. It only helps those that are left behind. What can be a benefit to you is asset protection that we'll talk about in the future. Okay, so what is different now? Traditional estate planning is based on you pass away, there's no complications, extenuating circumstances. It just goes from you to them. However, the world has changed and continues to change. It's not so much the nice, friendly, happy place that it used to be. It's getting more complicated, it's a little scary, a little whatever. It's bad stuff out there. So the world that I grew up in was much different than my children grew up in, and now we got some grandkids that are coming in, and it's a different place, more technical, less of the interpersonal connections. The other thing is most estate planning attorneys, so even those attorneys that specialize in estate planning. Now, typically, if you don't have will or trust, you're going to want to go to an attorney that specializes, that practices in that area. You don't want to go to a bankruptcy or divorce or personal injury, whatever. You're going to want somebody that knows what he or she happens to be doing. So a lot of attorneys that even do this, that even do some estate planning, they miss out on a lot of the really good opportunities that you can have for passing things down to the kids. And we'll talk about that in the next presentation. Basically, what I recommend is don't go online. Don't fill out. It's the lowest common denominator. You deserve better than that. I have clients that come in and say, oh, well, gee, I did my trust. I got it online. I paid, $500. I got this, and this. I said, well, can I see it? Sure. And so I take a look, and it's like, you got overcharged by about $495. This thing is really not good. You want something better than this, and there's a lot better things out there. Okay. The other thing is, again, with the world changing, traditional estate planning is based on assumptions that neither spouse has been previously married. Okay. If you're in a second marriage, you have kids from prior marriages, you have a lot of new complications, new issues that you have to deal with. You want to make sure that both sides of the family are provided for, taken care of. You don't want civil war. Most of my clients would rather burn their stuff, give it away, than have the kids fight. That's certainly what you want to avoid. You have a certain set of issues in second marriages. Again, that neither spouse had kids from before. Another thing is neither spouse dies prematurely. You have a whole bunch of other issues going on in the time between somebody passes away and whenever the survivor does. Something happens unexpectedly. There's a long span. Do you get married? What do you do with your life? How do you protect your assets, etc.? It's based on issues that the surviving spouse will never remarry. That frequently happens. Surviving spouse won't have any financial concerns. I should chuckle at this point. Traditional estate planning is based on assumptions that the surviving spouse will be cared for by his or her kids. Now, when my grandpa died, he was probably early 70s. My grandma lived to be 99.9. There was a long period of time there that she survived him. And so she had lived with one daughter and then with another daughter, and then that was in California, Sacramento area. Then my parents, when my aunt and uncle went on a mission, mom and dad came and lived with them for a year, and that was kind of the model back then of you just take care of mom or dad or grandma, grandpa. More often today, it's assisted living, it's something else. You just want to make sure that you have enough assets you don't run out of money before you run out of breaths. So you want to be able to make sure that there's means there to take care of the survivor. Okay, so being cared for by kids, not so much anymore. And my mom says, unfortunately, Mom did not have the foresight to have any daughters. I'm the oldest of 5 sons, and she loves her daughters-in-law, but she said, I love you guys, but I'm never going to go live with you. And this probably works out the best for everybody. She's in assisted living in Salt Lake. She loves it. Mother-in-law, the same thing. She's up in Heber City, and she sees it as her mission to help provide some entertainment to all those old people that are there. So that's her mission. Anyway, so typically what will happen is parent will end up in some sort of a facility. The other thing is based on what about extraordinary expenses, medical expenses, whatever these things come up. Being prepared, again, if you're prepared, then you're doing the right thing. More. Traditional estate planning based on assumptions that all of your kids will have stable marriages. That is less and less, the case. In the world it was 50% success rate. Typically in the church now it's getting there or close to there. None of your kids will have financial reverses or crises. So there is a way that you can do that. You can protect whatever you have accumulated during your life. You can pass it down to the kids in such a way that it's for their benefit. That, for example, it's their separate property. They inherit something from you. They get married. It's their separate property. They get unmarried. It's still their separate property. They're in a car wreck. Somebody sues them. Nobody can get it. You can protect those assets forever. And that's a nice thing that you can pass on to your beneficiaries now that most of the typical estate plans don't cover. Kind of the old version was you get it at age 21 or 25, or maybe you spread it out over 3 installments at 25, 30, 35, something like that. The problem is things can happen in between, and by the time you're 35, you're not set for life, and if you get cleaned out, then not a good thing. So you have the ability to protect your estate, your assets for them. None of your kids will ever get divorced. That happens. None of your kids will die before their spouses do. None of your sons-in-law or daughters-in-law will ever remarry. All of these things happen. It's happening all the time, everywhere. And if it isn't in your family, then you're fortunate and you're one of the lucky ones because it's happening a lot. Okay, close to the end here. So traditional estate planning, that none of your kids will ever need disability or government assistance. We can talk about how we can protect for that. You have no special needs children. And lastly, that all of your hard-earned assets acquired through your blood, sweat, and tears pass effortlessly without any complications or issues. And if that is the case, you're convinced that Cinderella is a fairy tale. It never happens in real life. I know I see a disproportionately high number of things happening in the world, and it's not a fairy tale. It happens. Okay, so those of you that are not medical professionals, you can still get this. In the 21st century, phenomenal advances in medicine, healthcare, the death rate in America is still 100%. So another fact is it is going to happen to you someday. I should put an asterisk on that as we approach the millennium. I don't know who's going to be translated and who isn't. In fact, let's see, Rex Lee, I had a constitutional law class from Rex Lee. He liked to tell this little story. He said, here's a book. It's called How to Avoid Probate, written by John the Revelator, and with a foreword by the 3 Nephites. So that is one way you can avoid probate. But for the rest of us, it's going to happen. And so the question is, are we going to be prepared? So what is the first question beneficiaries ask after they learn that somebody died? You all know the answer to that. It's how much did they leave? Now, we also know that the answer is always the same, doesn't matter who you are, and it's 100%. So again, This is your stewardship. This is your stuff. You want to make sure that it's used properly as part of your stewardship. It does not end when you pass away. It's how are we going to provide for spouse? How are we going to provide for kids? What are we going to do? Okay. Second question. When do I get it? Okay. All right. Wills versus trusts. Let's just break this down a little bit. So a will is a document. It's a formal, it's a legal document that you create that expresses your desires, your will, your wishes about how you want your estate to be handled. Okay. A lot of people think there's a misconception that having a will avoids probate. Not so. Having assets causes probate. So tell people that got to think of a will as a personal invitation to your kids to go to court. So the will equals probate, trust equals no probate. We're going to talk about how to set up a trust, how to do that, what probate is. So let's just go there now. So probate is a legal proceeding to clear the title to the assets out of your name to whoever you named in your will. Now, when I do presentations, I ask the class, how many of you have a will? And over half of them do. I said, no, that's close. It's actually all of you have a will. And if you don't have one that you put your wishes on, the state legislature has already provided this for you under intestacy laws. They know exactly what you want and where it's to go. And so you have that. But in any event, the nice thing about having a will as opposed to no will is you can name the old term is executor of the will. The more common term is the personal representative. So you can name whoever you want to be as the personal representative of your estate. It doesn't have to be in state. If you die intestate, which the terminology there is dying without a will, you have to have somebody within the state to be able to administer the estate. So, for example, I have had a client in Las Vegas. Husband had this is the wife. Wife had over $500,000 in an account in her name, okay? There was no payable on death. There was no joint tenancy. There was nothing, just 500 plus in her name. And so passed away unexpectedly. That, I don't know if anybody, I guess you'd have to have a long illness to expect it, but whenever your time comes and you're called to the great beyond, so wife died, this in Las Vegas, Nevada, which is a community property state. So husband comes into the office and, hey, my wife died. I've got this account. Can I get it? I said, sure you can, of course. However, because it was in her name only, going to have to go through probate. Oh, that's bad. I go, well, yes, it is bad. So again, probate is the process of simply clearing title to the assets from you to your beneficiaries. It's a state court proceeding, different than estate taxes. A lot of people think that they confuse estate taxes with probate, two different things. Taxes, government. Probate is the procedure, also government, but it's on the local level to clear the title to the assets. So, and the bad thing about probate, typically what most people think is money. So typically probate is going to be 3 to 5% of the cost. It depends on what state you happen to live in. Utah, for example, has uniform probate code that makes the probate process quicker, easier, cheaper, but you still got to go to court, so going to court, not good. Avoiding it, much better. So money is one thing. Second thing would be time. Typically, these things are going to be time-consuming. States like Nevada, probate courts are backed up. It's over a year. Here in Utah, it's a lot less. So anyway, so money, time, they can be contested. If somebody, and then the issue here comes up in second marriages, a lot of different kids. Somebody gets more, somebody gets less, however that works. So it can be contested. It's a public proceeding. There's an inventory of all of your assets. They're published, filed with the court. You have to have notice to creditors, notice to the beneficiaries. You go through all of these procedures. And whether it takes 3 months or 30 years, I've had an estate go on for 32, 33. It's been a while. Not a good thing. So probate is going to court. time, money, aggravation, and it eventually goes to the beneficiaries. So that's the probate process. So going back to client, so wife died, husband comes in, okay, I've got this account. It's community property, so I just get it. I go, no, it'd be nice if it worked that way. It doesn't work that way. So community property just means that it's owned one half by each spouse, regardless of whose name is on the title. But it doesn't pass the title directly to the surviving spouse unless it were held in joint tenancy or some other means or payable on death. We're going to be talking about that a little bit later. There's a whole set of problems there. Anyway, so died without a will. He does get it as a surviving spouse under the intestacy laws. He's the beneficiary. And so the problem is, by dying without a will, didn't avoid bond. And so the court, he said, well, I don't want to do it. That's dumb. I go, well, of course it is dumb, but this is the law. We're not talking moral and immoral. We're talking, here's what the law says. Okay, so he said, well, I want you to argue to the court that we don't have to do it. And so I said, we're going to lose. He said, I don't care. Okay, all right, I'll do it. Go in, Your Honor, would like to waive bond in this case. And the judge said, I'd really like to do this, but no, the statute says you have to, so you have to. So in other words, he is the personal representative of the estate, had to post a $500,000 bond. It cost him $5,000 to post the bond to protect himself as a beneficiary from what he may have done to himself as the personal representative of the estate. So does this make sense? Obviously not. We're not talking what makes sense and what doesn't. We're talking, here's the law. So what the law says, again, there's actually 3 requirements for probate. So one is that you have assets in your name only. Things that'll avoid that is holding in joint tenancy. Again, we're going to talk about that a little later. You can also have a payable on death designation, like on a bank account or brokerage or something like that. That will avoid probate. Things that typically cause, you have real estate, homes, title to the car, bank accounts, whatever, brokerage, any account, any asset that has a title to it, that's subject to probate. So things that avoid probate typically are IRAs, 401k, life insurance, other things that have beneficiary designation. So what happens is you have assets in your name that exceed the state amount to cause probate. Each state has a different amount. Utah, for example, California, Arizona, they're at 100,000. So you live in one of those 3 states. You have an estate, you have assets that are less than 100,000 cumulatively. It's not per asset basis, it's cumulatively. You pass away. If it's below the threshold, you can avoid probate. If it's above the threshold, got to go to court. These are the rules. So assets titled in your name exceeding the whatever the threshold amount is, and you pass away. So it's no ifs, ands, or buts. It's if your assets exceed the certain amount, you're in probate. Okay. So again, the solution to that, well, there's 3 ways to avoid probate. One is don't own anything. 2 is don't die. Or 3 is you can set up a trust. That's obviously the best solution. So let's go there. What I tell clients is, if you like your attorney more than your kids, get a will. Okay, probates are wonderful for attorneys. They get big fees it's all statutory. It's all very form-driven. You just check the boxes, jump through the hoops, do all of that stuff, and you get the payday at the end. If you like your kids more than your attorney, get a trust. So it seems like a pretty easy answer for most people, although some people just don't like their kids, but we won't go there. All right. So do I really need a trust? Again, if you own nothing and are never going to die, then that's not it. The ways around it, some people say, oh, well, I can do a payable on death or a joint tenancy. That's where we're going next. Okay, so do I really need a trust? Can't I avoid probate by holding everything in joint tenancy? The answer is a good attorney-like answer is maybe. Maybe yes, maybe no, with no being probably the better answer. So unfortunately, it doesn't ever work that way in real life, and there are always problems. It is never a good idea, which is kind of sad because most people, that's the way they do it because they don't know any better, or whenever they purchase their house, this is what the realtor told them to do, or title is hold it in joint tenancy. So better than not, if you don't have it in joint tenancy, it's what's called tenants in common, and one of the spouse passes away, you got to do a probate for his or her half of the estate. But again, trust is a better answer. Let's delve into joint tenancy. So what is joint tenancy? It's whoever lives the longest gets it, okay? It's a Las Vegas concept. It's double or nothing, winner takes all. So you live long enough, you survive the other person, it goes to you. So what are the requirements? Several. One is you have to have 2 or more humans, all right? Can't have joint tenancy with an entity. The entity never passes away. So it's, are you alive or are you not? That's the issue. So 2 or more, you can have any number. Doesn't need to be husband and wife. Could be parent and child. Unmarried couple, that's not you, that's your neighbors. And again, you can't have it with an entity. So those are the requirements for joint tenancy, 2 people. Okay. Disadvantages are it really doesn't avoid probate. What it does is it defers it until the second spouse dies. And a lot of people will say, oh, well, that's fine. I'll just have time to, my husband promised me he's going to go first, and who knows, 50-50 chance there. So whenever first spouse passes away, I'll just add the kids on the title, and it all passes to them really easily. I don't know if you can see any problems with this. There are quite a few. Number one, it doesn't cover simultaneous deaths. Also, you may have good intentions to do it, but the good intentions don't get you too far if you never implement it. And the other thing is inertia is a very powerful force. Especially if it's the unknown, oh, I don't want to talk to an attorney, it's going to cost me money. I don't want to think about dying, we'll just deal with it, next year, next week, next whatever. And sometimes the next whatever never comes. So doesn't cover simultaneous deaths, which is especially dangerous in the case of second marriages. So let's talk about that. Why is that? It's 0% goes to the beneficiaries of the first one to die and 100% to beneficiaries of the last one. And so husband and wife, they're in my office. Hey, did you ever consider this? So you guys are in the car. You're driving, so you, Sister Jones, your husband, well, you've complained about his driving all your life, and now you know about this. So he gets in an accident. What happens is, and he's not even polite enough to have him go first. Car comes from the other way. You go first. So you die immediately. He's, 3 seconds later or 3 days later, whatever, as long as it's 1 millisecond. If he survives you, if you held everything in joint tenancy and he passes away shortly thereafter, your kids get 0, 100% goes to his kids. Is this really what you want? Well, of course not, Don't want to do that. I said, well, okay, so there are steps that you can take, but joint tenancy is not it. Okay, so going over some of the disadvantages. We're going to go over this too a little bit, is for those in community property states, different than separate property states. We'll do a map and show you who's, where you are if you don't know. Why is that? There's actually some really good tax advantages, at least for step-up basis and income taxes by being in a community property state as opposed to a common law state, but don't recommend you moving to California or Nevada, Arizona, whatever, just to get those tax advantages. So under law, joint tenancy is not treated as community property. It's treated as separate property owned 1/2 by each spouse. So if you live in a community property state and you hold things as joint tenants, then you've converted what used to be community property into joint tenancy, into separate property. So the magic comes here is that in community property states, you get a stepped-up basis on the death of one spouse. You get a stepped-up basis on both halves. Okay. Let's do the map here. So we're missing Alaska, Hawaii, but neither one of those are community property states. Now, community property that's not a common law English-based law. It's more of a Spanish law. And so typically it's in the Southwest, but we're going to start at the top, and which actually I think is superior. I like community property more than separate property. So what community property says is it doesn't matter which spouse is named on the property, each spouse owns half, which is the way it should be in my opinion. So Washington, yes. Idaho, they by statute. Nevada, California, Arizona, New Mexico, Texas, and Louisiana. So you can see it's kind of the southwest part of the U.S. that had the Spanish influence before, New England and the British-based law came over. Then we have some outliers. We have Wisconsin and Florida. You can actually opt into it. So, but let's just go there for the benefit of those of you who are in community property states will pay attention, and the others you can see if you want to move. All right, so we'll say we have John and Mary, and they bought property for $100,000. Okay, so for tax purposes, this is their tax basis, $100,000. That's what you use in determining capital gain. So it's a capital asset, it's a house, it's a stock, it's whatever it is, and it appreciates in value. The difference between your tax basis, whatever you paid for it, and whatever you may sell it for, that is what's known as capital gain. Better than ordinary income. It's taxed at 20%, and then you have some other little tweaks, up and down, but for all intents and purposes, we'll just use the 20% number. Okay. So they bought it for $100,000. Property's now worth $250,000. Okay. John and Mary sell it for $250,000. Is there any capital gain? Well, yes. Don't have to be an accountant to figure this out. How much? It's $150,000. So difference between what you bought it and sold it, capital gain, reported on your tax return. Again, not taxed as ordinary income. You get the capital gain rates, which are better. So that's a good thing. All right, so let's keep going. Same facts. Let's say they hold it in joint tenancy. So this is where everybody is now if you hold your property in joint tenancy. So, and actually, if this is going to be real estate, we should say you bought it at $300,000 and it's worth $1 million if you've held it for more than 2 years, whatever. So John and Mary hold it in joint tenancy. John has the good sense to pass away, which I tell people, my wife and I, we've worked this out. We both agree that I get to die first. She says it would, if she died first and I remarried, that would bother her. And for me, it would bother me to be alone. So it works out for both of us, if I happen to go first. Although I do have one client, he was an older gentleman. He told me, do you know why husbands die first? I go, well, because we're older generally and genetically inferior to our spouses. He goes, no, it's because we want to. I go, oh. And she's sitting there and it's like, okay, you've been through this before. All right. So in any event, we'll just go with the odds. John is a few years older and he's male, and so he dies first. John's half of the property gets a stepped-up basis. Okay. So that's one of the rules is whenever somebody dies, the basis in the property, whatever you paid for, gets stepped up to fair market value, meaning that you avoid any capital gains on that. So frankly, this kind of plays in, a lot of clients say, well, I just want to give my assets to my kids now. So that's not a good, bad idea. Here's a couple of reasons. One is you never want to do that because you don't know what's going to happen to the kids in your life, They get divorced, they get in a car wreck, something happens, and if you've already given your assets away, and something happens to one of the kids, now you no longer have your home. So bad ideas first on that. The other one is on taxes. It's much more tax efficient to pass property from you down to the kids when you pass away because you get the stepped up basis. So that's the concept there. All right, so John dies. Mary said, oh, whatever this was, this cabin in Duck Creek, I like it, but, I don't use it enough and I'm getting older and, we're just going to sell it. Is there any capital gain, taxable gain? The answer, of course, is yes. How much is it? Well, the good news here is it's half of 150, it's $75,000. So by passing away, you've minimized the taxable gain whenever Mary passes that away. Now, let's contrast that with property, community property. Okay, so John and Mary, same facts. John dies. Would the result be different? Yes, because upon the death of one spouse, you get stepped up basis on both halves of the estate. Mary sells the property. Any taxable gain? No. Okay, so that's good. Again, it's much more beneficial to the kids to inherit something than you give it to them during life. So if you give something during life, they have what's called a carryover basis. Namely, if they have this asset worth $250 and they give it to the kids, their basis is $100. The basis for the kids is $100, and whenever they sell it, now the kids have to pay the taxable gain, the capital gain on that. So if they own it, pass it at death, zero tax. Much better for them. A lot of people, they question, they say, well, what about, is this income to the kid whenever the child, your beneficiaries, whenever they inherit? And the answer is no. This is not income, it's a bequest. All right, here's one of the things is several states now, because of the benefit of this, the disadvantage of holding property as joint tenancy, they will allow you to own that same account in a community property state as community property with right of survivorship, as contrasted with joint tenancy as joint tenants with right of survivorship. Problem with this is even if you live in a community property state, is there's banks, broker, you get the national companies, they don't understand community property, they don't have that option. Okay, so if it's bad for husband-wife, it's even worse if you have, parent-child. Okay, so again, the strategy of some people is, I'm just going to, husband, of course, going to die first. I'm just going to take it. I'll add the kids on later. We'll just keep doing joint tenancy and avoid probate. It's even worse. Okay, so why is that? Mom dies. You only get a 1/3 step up in basis, or if you get 4 kids, you've got a 20% step up in basis, etc. So as you can see, the more people that you add on there, the worse the tax situation gets. All right, so that's bad idea. All right. So taxable gain is 100 instead of 75. All right. The other thing, like we touched on a little bit earlier, is do you really want to expose your kids, to expose my assets, to the claims of my kids? And the answer is emphatically no. So you have children on the title. What can happen is something bad happens to them, all of a sudden you don't own the house anymore. So what happens if your child gets divorced? The spouse is going to come after that. They can attach a lien on the house, which if you ever sell the house, you're going to have to pay off the lien, or they frankly can foreclose, which would be bad. Or in a car wreck, the kid has a business failure, medical expenses, something happens to your child. If you have added them onto your property, whatever your account or real estate, you've exposed your hard-earned asset to what happens to them. But it can get even worse. So in this case, we have mom and a couple of kids. If one of the children dies before mom does under a joint tenancy, their kids get disinherited. And so joint tenancy, there's no sophistication, there's no fun things you can do. It's just count noses who happens to be alive when somebody died, and title goes to those people. And so in this case, if daughter had died prematurely and had 2 kids, instead of her share going down to her kids, it goes to the other beneficiary. So that's something most people don't think about. Similarly, the other thing is you can't provide asset protection to your child through joint tenancy. You can in a trust. And it's bad things happen if you don't want family feud. Most of my clients, say that if they'd rather burn it all, they'd give it away, whatever, than to have the kids fight. That's the last thing they'd want. Okay, true story. We have mom had a CD for $400,000. She had 4 kids. The math is good. I can figure this one out. That would be $100 each if she did it, but she didn't do it. 2 of the daughters were in town. 2 sons were out of state. Okay, so what did mom do? Well, she put the account in her name with the 2 daughters as beneficiaries because that's the more convenient thing. I don't know what's less convenient. I mean, you could easily add 4, but she thought it was convenient. And that the daughters would do the right thing. That does happen sometimes, but not very often. Okay, so what happened was they didn't do it. They weren't obligated to do it. They didn't do it. And so what they came in, got the calls from the sons, hey, what's going on here? I said, listen, I'm sorry. I tried to talk mom into doing this here, and, she wouldn't do it. She just did this. And then the daughters, their position, of course, is, well, mom could have easily added my brothers on, but she didn't, because we're here taking care of her and we deserve it. And we're the ones that were dealing with this all the time. And so she wanted us to have more, and we deserve this and more. And so what happens is Thanksgiving dinners are never the same after that. These things, I have heard of grudges, 30 plus years that they're not speaking to each other because of whatever was said way back when, which is silly, but it happens. Anyway, so don't do it. All right, here's another one. Mom moved to Las Vegas from Chicago. Good move in my opinion. Bought a home. She wanted to avoid probate, so again, doing the self-help remedy. I have a daughter in Vegas. I'm just going to add her onto the title. And so it's mother and daughter, joint tenants with right of survivorship. Okay, so if mom died, it would have gone to the daughter. However, it would have been a carryover basis. Daughter would have had, taxable gain whenever she sold the property. Again, the much smarter thing would have been to hold it in a trust, get the full step up in basis, but she didn't. Okay. People do the, dumbest things. They don't realize it's dumb, but, you don't know what you don't know. And so that's why it really makes sense to talk to somebody who does, that can help set you up in the right direction. Okay. All right. So she put her daughter on joint tenants with right of survivorship. She decided to move back to Chicago. Again, I assume that was August and not January when she made that decision, but whatever she did. So mom put the house up for sale, found a buyer. Daughter, of course, you have both names on the title, so she's required to sign at closing. And just one little glitch is she said, no, you're not selling my house and moving away. What's going to happen to the money? And you may spend it all. And, this is my inheritance. And so daughter refused to sign unless she got half of the proceeds. Good news is your kids would never do that. The bad news is there's a whole lot out there. So at least you're better. You can talk to your neighbors and talk them out of it in case they wanted to do something not so smart. All right, so here's another story. True story. Here's, like my dad always told me, truth is stranger than fiction. I said, well, why is that? And he said, fiction has to make sense. That doesn't always happen in real life. I go, okay, that's a good point. Dad was smart. All right. So here's another one. Mom bought a house in Las Vegas, put her daughter on the title. The daughter, who's an assistant DA, moved in with her boyfriend, not LDS, of course, and her 14-year-old daughter. So here's mom, daughter, boyfriend, granddaughter move into the house. Recipe for bad things happening, but I guess she thought it was a good idea at the time, whatever. Mom got tired of her guests, but they said, no, we're not going to move, and she couldn't force them out because daughter was on the title. She didn't have any right. She had the right to be there, and she could invite whoever she wants to. And in this case, so mom said, okay, if that's going to be, if you're going to do that, I'm just going to sell the house. And daughter says, fine, you can sell our house, and I'm going to be there at closing. And so daughter refused to sign the closing papers unless she paid her mom $160,000, and also because she was an attorney, she prepared the agreement to hold her harmless for whatever it was. So again, this will never happen to your kids, but you can warn your neighbors from this point. So moral of the story is, don't put anybody else on the title to your house. Okay. Here's the last one. This is the saddest story for me. So mom did the right thing, or she thought she was doing the right thing. She had money, daughter not so much. Well, I'm going to be nice and generous. I'm going to buy you a house, and I'm going to put it, which that could be good, except she put it in daughter and husband's name. You might see this one coming. Okay. So the title was issued in daughter and husband's name, joint tenants. Well, of course, we don't want joint tenancy, but that's not where this story is going. So what happens years later is daughter and husband happen to be divorcing, and husband had moved out of state. So you have daughter and granddaughter living in this house. So far, so good. He's gone. And what happens is, before the divorce was final, she unexpectedly died. So under joint tenancy, what's going to happen is the title automatically passed to who was going to soon be her ex-son-in-law. And so mom came to her and said, hey, you know what? I bought this for my daughter. You just happened to be married to her at the time. But now that she's gone, I really want this to be held for my granddaughter, because she's going to need it, and we can sell it, and she can go to college or whatever stuff she's going to do. And she asked very nicely, and you know what happened there. Guess what he said? And the answer was not just no, but was adjective no, exclamation point. Okay, and so this only happens, it's not scientific, 99.99, but, they're in the middle of a divorce. It's just not going to happen. Okay, so summary on this long section here about joint tenancy, dangers, limitations is, number one, you lose the income tax basis, no step-up basis on on both halves. Creditors of the other joint tenant can attach property, so it's you don't want the kids on there, and you lose the ability to protect beneficiaries. So, all right, joint tenancy, bad. Trust is better if you might be thinking you might pass away sometime in the next 50, 100 years. All right, so let's do an example here. So we have John and Mary. Let's say these guys are normal. It could be. It's less and less likely these days, but let's say they are normal. And we have all assets are held in joint tenancy, or they have a beneficiary designation, okay? So far, so good. Let's just give them some stuff. So let's say they have a house, a couple cars, bank accounts, savings accounts, some rental properties, investments, so stuff. So they have those things. All of those are assets that are titled in their names, okay? Another class of property, IRA, 401k, insurance, personal property. Set this in a different category because each of those things has a beneficiary associated with it. Okay, so how the beneficiary designation works is it's by contract. The company will pay it to whoever. Here's a death certificate, John passed away, Mary passed away, whatever. I'm the beneficiary, cut me a check, so that's how that works. The other thing is personal property, where technically it's subject to probate. Chances are it's not going to be an issue. Whenever we do a trust, we have a blanket assignment of all personal property into the trust, and so it's not an issue. But no title associated with that. Okay, John does the noble, honorable thing, and he passes away first. Question, is there a probate? And when I do this live, people say, of course there is. And the answer is, no, you weren't paying attention. It's in joint tenancy, so it avoids probate. Okay, got it, right. So no probate. Why? Because it's in joint tenancy or a beneficiary. Okay. Eventually, Mary's going to pass away. That happens. Is there a probate? Now you can answer yes. Okay. And why is that? Because the assets are held in her name. Here's just a little thing here about the different states. Threshold, 275 in Oregon, 200 Wyoming, California It depends on what you have there. Utah, Idaho, Washington, and Nevada last place at 25. So basically, if the assets exceed that amount, or if there is any real estate, it is subject to probate, going to court. Again, court, good for attorneys, bad for beneficiaries. Avoiding court, good for beneficiaries, not so good for attorneys. Okay. All right. So that's their situation. So John passes away. Here's Mary. She's eventually going to pass away. Here's what this is going to look like. So the assets, to the left there, IRA, 401k, beneficiaries, it passes to the kids. Average in America is 2.3, but we tend to have more than that, so we're going to leave that blank, however many kids you have. Assuming you like all your kids, which, by the way, loving is mandatory, liking is optional. And one of the advantages of having more than one is hopefully at some point in time, one of the kids is going to like you and vice versa. But no matter what it is, she's going to have it equally to the kids. But all of those assets there drop into probate. So the house, the cars, the bank accounts, anything that has a title to it is in court at that point. Again, probate is a local procedure. Whatever county the decedent happened to live in, that's the jurisdiction for doing the probate. So again, downside of probate, it's going to cost a bunch of money. It's a public proceeding. It's going to take a whole bunch of time. It can be contested. Sometimes that happens if you have, again, in a second marriage, kids from other, hey, well, we already inherited for this. We should be getting half of it. We should be getting our share of this, but this already came off the top. We don't like it. And anyway, Civil War, don't want that. It's a pain in the rear. It'll eventually go down to them. So the good news is it'll eventually go down to the kids. The bad news is you got to have a court procedure, which is time, money, aggravation. All right. So let's bring John back here. So what's one of the other options? They could have set up a trust. So family trust, revocable trust, living trust, a lot of different names. It's all the same thing. So they create this trust. I tell people, think of it as a box. So they have created this box, this trust. As a revocable trust, they can amend it whenever they like. Okay, so change trustees, change beneficiaries. When you change assets, you never have to even amend the trust. So John and Mary are the trustees. They have complete control of the trust throughout their lives. So they're going to sell, well, let's give them some assets. Okay, so here's their assets again. What they're going to do, transfer it to the trust. So no assets in their name. Everything is now held in the trust. So let's say we're going to sell the house. Okay, that's fine. Well, clients ask, is there any complications? And the answer is no, there is no complications. So the trust sells it. So the house goes, so we go to closing, title, buyer comes in, here's the money, we're financing it, whatever we're doing. Here's the money for the house. Money comes in, house goes out. So the trust is selling the asset, not John and Mary. Okay, so the money now belongs to the trust. They've got the bank account. They deposit the funds into the trust, and then they do whatever they want to. Buy another house, money goes out, next house comes in, et cetera, et cetera. So again, John and Mary are trustees of their trust. What I tell people is you never have to amend the trust as assets change. People say, well, do I have to come see you every time I get something? I said, I would love to visit with you, but I absolutely not. You don't need, nobody else needs to be involved in this. John, Mary, you do whatever you want, or more likely, a lot of times what happens is Mary does whatever she wants, and John will do whatever Mary wants. I don't know how your family is, but anyway, that could be the case. So they are in charge of whatever their assets are, come and go, ad infinitum, makes no difference. The only time you'd ever have to amend the trust is if you change your mind on humans. So I'm changing trustees or I'm changing beneficiaries. That's organic to the box. It's not what's in the box. So again, you create the trust, think of it as a box, put things into the box, take things out. You're in charge throughout your life. As a family trust, revocable trust, again, to contrast this with some of the other options that are available, family trust has zero asset protection. So John gets sued. Having in the trust is no barrier. It's not an impediment. Any creditor of John's can get into the trust, or Mary, whatever. Of course, Mary would never do anything wrong, but anyway, if it happened, they get in. Again, on the fourth of these lectures, There is another option. You have 3 of the states, again, Wyoming, Nevada, Utah, allow for asset protection trusts. That, to contrast, is an irrevocable trust. So irrevocable trust is different than you. Family trust, revocable trust, alter ego of you, irrevocable trust, different than you. Just a little, so the spoiler here is all 3 states, you hold the assets. After the assets have been held in the trust for 2 years, the barriers come up, the force field is there. Nobody can penetrate that no matter what happens. So they do have that as another option. Listen to the 4th lecture and we'll talk about asset protection trust. But again, going here. One of the other things that people ask is, oh, well, my house has a mortgage. Do I have to pay it off before I can put it in the trust? And the answer is no. Okay, so there actually is even a federal statute that says no lender can call a loan due, exercise the due on sale clause when you transfer it to somebody else. No, having a mortgage doesn't make any difference. You can put that in. Okay, so we have John and Mary set up the trust, transfer the assets in. Again, they're in charge of the trust. They do whatever they want to throughout their lives. Okay, John passes away. Mary is the successor trustee, so she just keeps on. Nothing changes legally as far as the documents go. Essentially, one of the things that I tell people is by setting up the trust and transferring your assets in, you are basically doing your probate in advance. Probate, again, is just clearing title to the assets to whoever is supposed to get them. Putting them in the trust, you've already changed the title to the asset. It's no longer in your name. And so you now have, basically, you've done the legal stuff in advance while you're here to deal with it, which is much faster, cheaper, easier, better than making your kids do it when you're gone. All right. So again, Mary controls all investments, distributions throughout her life. She just does whatever she wants to. All of the assets continue for her support throughout her life. So again, typically, you're not going to have anything passed to the kids until both John and Mary are gone for lots of different reasons. All right, so let's go back here. Again, same situation. They set up the trust. John passes away. Mary eventually passes away too. Is there a probate? I'm hoping you're all on the no, okay, which is the right answer. So we have these assets that have beneficiaries associated. Those go directly to the kids. Same thing with the family trust. So again, I probably didn't explain this well enough before. So the family trust is essentially your will substitute. And so what you would put within the family trust, what you would put in the will, like when I pass away, I've got, 5 kids. I want it to go equally 5 ways among the kids. That's easy. You say, oh, well, what if I have a special needs child? I can't really, have it go to him or her. I'm going to give it to somebody else. Hold it for that child. It's like, no, that's not a good idea. There are abilities that you have within the trust to take care of your child, set up a special needs trust within your trust, and they can still be taken care of. You don't have to do an off book. It can be straight up through the trust. So anyway, family trust acts as a will substitute. So what would happen is typically you can name one of the kids as a beneficiary, name one of the kids as the successor trustee. So similar to an executor of the will, the terminology is a little bit different. It would be successor trustee to the trust. So I'm the trustee now, or my wife and I are trustees of our trust. I pass away first. She's the successor trustee. She just carries on. We had named, oldest son, youngest daughter. We have, them. We can name whoever we want to administer the estate. So what they would do is similar thing within a will, except you're not going through probate. Sell any of the assets that need to be sold. Pay off any debts, make sure you're solvent, divide by 5, cut some checks. Or again, as we're going to talk about in the next lecture, there's some fun things you can do to help protect each of the kids. But in any event, you name whomever you want as successor trustee of the trust. That person steps in and just administers it. The nice thing is it's outside of the legal system. You don't have probate court. So the cost, instead of a whole bunch going through court, is 0. The time is not a year or 6 months or whatever it happens to be, depending on whatever state you happen to live in. The time is however long it takes you to do it. There's no time restrictions. Public record is none. So another thing just to contrast a trust versus will. Will is a public record. So you file it with the court. Everybody can see, anybody can go to the county clerk and see the will's been recorded, or filed with the court. I can see who's getting something, who doesn't, whatever it is. Trust is never filed. It's not recorded. It's a private transaction just between you and yourself. Nobody even knows the trust exists unless you happen to tell them about it. So it's a nice way of being anonymous. So no, it's not a public record. The other thing is you can't really contest in the trust. Most of the trusts will have whatever we do. We have essentially the no contest clause that says if you contest it, you get disinherited. And so that's a big disincentive for somebody to say, hey, I don't like what you did. I'm going to contest. In a will, you can throw sand in the machinery and it all comes to a halt. It doesn't have to have merit or whatever. You can use it as a nuisance factor, and I've seen that happen of just, I'm an annoyance, you got to pay me off, or I'm not going away. And so within the trust, you avoid all of that. There really is no forum to contest it. So that's kind of the summary there, and again, it's much easier. So the limitations of trusts, kind of wrapping this up, what won't a living trust do? Again, like we talked about, it doesn't give you asset protection during your life, okay? Long time ago, people focused mostly on getting asset. They used a trust to avoid probate and estate taxes. Today, more concerned, about protecting what you have so that you're not cleaned out. There is something to go. So, summary is living trusts much better than wills. It's the easiest, best, cheapest, fastest, coolest, slickest way to do it, all right? You avoid probate, better than joint tenancy, better than wills, and you can protect your beneficiaries. So bottom line is we're all going to go sometime. This, again, is part of our stewardship. It's our responsibility. I have a lot of clients say, well, I don't care. I'm just going to let them figure it out. And that's the answer. That's no. You're doing them a disservice. But I don't want to offend. I don't want to name the youngest child to be in charge because that'll offend, the older, whatever. I said, well, number one, good. You don't have to worry about being offended because you're not going to be here. Let them worry about it. But what you do, the concept is, it's each of us, it's our responsibility to arrange our affairs in such a way that we avoid these problems. And so what I have found is that if you will take the time, clearly state your objectives, what's going on, what you want to have happen, who you want to deal with it, your kids will respect it. They may not like it, but they will respect it. The worst thing you can do is to leave it up to them to figure things out. And if they have potential for any conflict, that, you have different, I've seen it, you put $20 on the table and personalities change. It's kind of sad, but weird things happen once you're not here. And so you owe it to yourself, you owe it to your children, you owe it to, I guess, your posterity to do things correctly. So that is the summary of this, the basic estate planning, what you should do, what you should avoid. I hope this was helpful. If you'd like to know more, the next presentation, we're going to go into more detail on what kind of fun things you can do within the trust for the kids. So hope to see you next time.